Hello, today I will be informing you about the Brown versus Board of Education case. On May 17, 1954, in a milestone choice on account of Brown versus Leading Group of Education of Topeka, Kansas, the U.S. Supreme Court pronounced state laws building up discrete government-funded schools for students of various competitions to be legal. The choice destroyed the ultimate structure for racial isolation in state-funded schools and Jim Crow laws, which restricted the privileges of African Americans, especially in the South. Elementary schools in Kansas had been isolated since 1879 by a state law permitting urban communities with populations of at least 15,000 to build up discrete schools for black and white children. African American guardians in Kansas started documenting difficulties as ahead of scheduled as 1889. By 1950, 11 court difficulties to isolated schools had arrived at the Kansas State Supreme Court. None of the cases effectively toppled the state law. In 1950, the Topeka chapter of National Association for the Advance of Colored People coordinated another case. This time, a class activity suit contained 13 families. The reason for the offended parties' complaint was that their child had to walk or take a ride in the car to school when there were white schools near their home. The Topeka NAACP documented suit for their sake in February of 1951. However, by August, the U.S. District Court decided that despite the fact that isolation may be adverse, it was not unlawful. Referring to the U.S. Supreme Court choice in Plessy v. Ferguson, 1896, the appointed authorities denied because the highly contrasting school in Topeka were equivalent as for structures, transportation, curricular, and instructive capabilities of educators. The Supreme Court justice heard the case in the spring, yet couldn't choose the issue before the finish of the court's term in June. The justice chose to rehear the case in the fall with unique consideration paid to whether the 14th Amendment's Equal Protection Clause restricted the activity of discrete state-funded schools dependent on race. Warren had the option to carry the justice to a consistent choice. On May 14, 1954, Chief Justice Warren conveyed the assessment of the court, expressing, "We presume that in the field of government-funded instruction, the precept of separate, however equivalent, has no spot. Separate instructive officials are intrinsically inconsistent. In this manner, we hold that the offended parties and others likewise arrange for whom the activities had been bought, are by reason of the isolation of denied of the equivalent insurance of the laws ensured by the 14th Amendment." The choice, Brown versus Board of Education, constrained the integration of state-funded schools in 21 and strengthened opposition in the South, especially among racial oppressors, gathering and government authorities throughout to the segregationist cause. In Virginia, U.S. Congressperson Harry F. Bard Sr. began the massive research. The choice in Brown versus Board of Education constrained the integration of state-funded schools in 21 states and strengthened opposition in the South, especially among racial oppressor gatherings and government authorities throughout to the segregationist cause. In Virginia, U.S. Congressperson Harry F. Bard Sr. began the massive resistance development, which tried to pass new state laws and approaches as a method for holding government-funded schools back from being integrated. And perhaps the most infamous example of protection from the choice, Arkansas governor got down on the National Guard in 1957 to hold black children back from entering Little Rock Central High School.